Charlie was born on the 4th of August last year, so he is now 10 months old. He had all the appearance of a normal baby at birth, but he has a rare inherited disease, infantile onset encephalomyopathic mitochondrial DNA depletion syndrome, otherwise known as MDDS. This means that his condition has deteriorated seriously since he was born. He cannot move his arms or legs or breathe unaided. His brain is also severely affected, and there was a significant decline in the level of his brain functioning in January this year. He is kept alive by a mechanical ventilator. His parents agree that his present quality of life is not worth living, but they have been offered the prospect of a new treatment in the USA, deoxynucleoside therapy, which it is thought might result in some amelioration of his condition. This has never been tried on human beings or animals with this particular disease. The judge, having heard the evidence, concluded that, quote, the prospect of the nucleoside treatment having any benefit is as close to zero as makes no difference. In other words, as I have said, it is futile. End quotation. Any court is bound to feel utmost sympathy for devoted parents who are desperate to explore every possible way of preserving the life of their gravely ill but much-loved baby son. As parents, we would all want to do the same. And this case is unusual in that the parents are not asking the hospital to provide or continue treatment at public expense. It is the hospital which has asked for permission to withdraw artificial ventilation and provide only palliative care. Charlie's parents are asking that the hospital continue to keep Charlie alive by artificial means until they can take him to the United States for the treatment which has been offered there, and for which they have raised the funds to pay. How, they argue, can the hospital try to prevent them from transferring the care of their son to another team? However, as judges, and not as parents, we are concerned only with the legal position. We are bound to accept the factual findings of the trial judge, who has heard the evidence, including the evidence of the doctor in the USA who is prepared to offer treatment, and the judge who found that further treatment would be futile. The legal test which he applied was whether further treatment would be in Charlie's best interests, and in his order he has expressly declared that it would not be. The parents argue that this is not the right legal test. In this sort of case, the hospital can only interfere in the decision taken by the parents if the child is otherwise likely to suffer significant harm. That apart, it is argued, decisions taken by parents who agree with one another are non-justiciable. Parents and parents alone are the judges of their child's best interests. Any other approach would be an unjustifiable interference with their status as parents and their rights under Article 8 of the European Convention on Human Rights. But there are several answers to this argument. Firstly, applications such as this are prescribed for by statute. The Children Act 1989. There was an application for a specific issue order in this case, as well as under the inherent jurisdiction of the High Court. Both are governed by the same principles. Section 1, subsection 1 of the Children Act 1989 provides that the welfare of the child shall be the paramount consideration in any question concerning the upbringing of the child in any proceedings. This provision reflects, but is stronger than, Article 3.1 of the United Nations Convention on the Rights of the Child, which says that in any official action concerning a child, the child's best interest shall be a primary consideration. Furthermore, where there is a significant dispute about a child's best interests, the child himself must have an independent voice in that dispute. It cannot be left to the parents alone. And this has happened in this case because Charlie has been represented by a guardian, and that guardian has investigated the case in his best interests, and the guardian agrees with the hospital and with the judge's decision. So parents are not entitled to insist upon treatment by anyone which is not in their child's best interests. Furthermore, although a child can only be compulsorily removed from home if he's likely to suffer significant harm, the significant harm requirement does not apply to hospitals asking for guidance as to what treatment is and is not in the best interests of their patient. As the Court of Appeal found, it is in any event likely that Charlie will suffer significant harm if his present suffering is prolonged without any realistic prospect of improvement. This was found by reference to the judge's conclusions on the evidence. And finally, the European Court of Human Rights has firmly stated that if in any judicial decision where the rights under Article 8 of the parents and those of a child are at stake, the child's rights must be the paramount consideration. And if there is any conflict between them, the child's interests must prevail. In short, therefore, it is quite clear that the hospital was entitled to bring these proceedings. The judge was required to determine the outcome of these proceedings. In doing so, he applied the right test, and his factual findings cannot be challenged on an appeal. It follows that the proposed appeal does not raise an arguable point of law of general public importance, and so permission to appeal must be refused. Mr. Gard.
My lady, in terms of
Mr. Gordon, I was a family division judge for many years. I am thoroughly familiar with the intensity of feelings at cases like this.
I knew I didn't have to explain anything about it. The question, I think the court knows that we have put an application preemptively into the Strasbourg court, and what we're told is it's a Rule 39 application. Mm-hmm. And what we're told is that we will get a decision, we should get a decision, what we had been told, I should say, is we should get a decision by midnight, which would still be within the time given in respect of the order originally made by the Court of Appeal. I think by the Court of Appeal it would continue until the decision of the Supreme Court, continue until midnight tonight, or further decision of the Supreme Court. I'm told by Mr. Payne, who has kindly indicated his attitude for the government or Department of Health, that what he's been told by Strasbourg is that there may be, we may get the decision within 24 hours. I think that was the information I was given, which would be...
They indicated that they would welcome a 24-hour, that Strasbourg would welcome a 24-hour stay.
From the court?
Yes.
Well, that's what I would obviously ask for that in order that Strasbourg can continue its consideration and give us a decision, because the order of the Court of Appeal will otherwise expire. And so we simply ask for a stay until Strasbourg has given us its decision on the interim application.
It might be, Mr. Gordon, that if we were to grant a stay, and we may have to retire to consider that,
yes,
in the light of any further observations, we would be inclined to put a time limit on it.
Yeah. Yes. Well,
in everybody's best interest.
Obviously, we would abide by any order your ladyship makes, but that's what we would ask for, given the information given to me by Mr. Payne.
24 hours is what you want.
Yeah.
Yes.
Great.
Yes. Ms. Gollop. Yeah. Is there anything you want to add to that, Ms. Butterkill? Yeah. We'll just retire for a moment.
Great.
All rise.
Mr. Gordon, we have decided to order that the order made by Mr. Justice Francis on the 11th of April 2017 be stayed until 5 p.m. on Friday the 9th of June, in order that the European Court of Human Rights can determine the appellant's request under Rule 39 of the Rules of the Court for an indication to the United Kingdom of any interim measures which it or the President considers should be adopted in the interests of the parties or of the proper conduct of the proceedings before it.
Thank you very much, my lady.
Thank you all very much indeed, as I said before, for your submissions, both orally and in writing, in this obviously sensitive case. And the court is now adjourned.